Yep, there we go. Shouldn't be. Morning. Morning, sir.
Good morning, all. We're here for a pre-trial review in the matter CFI 21-2015 before His Excellency Justice Ali AlMadhani. The claimant is represented by Curtis Malin Prevost, lead counsel is Theron and The defendant is represented by Mayor Brown, lead counsel is Harris Bohr, assisting is Alistair Graham.
Yes, good morning. Well, I have problem hearing you. I shouldn't the recording system working. I can hear you, but not clearly. Yeah, a little better. It's okay, go ahead, Ms. Fraga.
Yes, Your Honor. We're here for the pre-trial review. However, I want to clear there are a certain number of applications pending today before the court. An application filed by the claimant by the original order to permit the claimant's witness, Mr. Krayushkin, to give evidence by video link. An application filed by the defendant to amend their pleadings, and another application filed by the defendant for security for costs.
Right.
If Your Honor would like me to address the claimant's application first.
Yes, I agree. I've seen the three applications, and it turned to be like a case management conference instead of pre-trial now. But I'm willing to hear and we'll decide later. Yes, I'll allow you to go ahead and present your client's application. Go ahead.
Yeah, the claimant filed an application for a provisional order. The claimant's witness, Mr. Igor Krayushkin, be allowed to give evidence by video link and
Would the defendant counsel please put the mic away from the paper? Do you hear me?
We do. You're with me with the mic.
Yes, please. Okay. Just make it closer once you have the turn to speak, please. Okay, that's better.
Thank you. Your Honor, the claimant's application for evidence by video link is a proactive application because it may not be necessary for the claimant, in fact, to give evidence by video link. As the court is aware, the claimant's witness, Mr. Krayushkin, has been the subject of a criminal proceeding, criminal investigation, starting from the subject matter of this claim, and in particular with relation to two bounce checks, which were provided by Mr. Krayushkin to the defendants under the tenancy contract. On 19 April, last week, claimant's counsel sought respondent's counsel consent for the evidence of Mr. Krayushkin to be given by video link. But for the first time on that day, the respondent's counsel informed the claimant's counsel that in fact there were no criminal charges pending anymore. Therefore, representative of the parties on 20 April attended the Bourgeois police station, and a police officer confirmed orally, we were not able to obtain anything in writing at the time, that the case against Mr. Krayushkin is indeed closed. Although this is certainly a positive development, criminal charges were withdrawn only last week, and it may be difficult for Mr. Krayushkin, who has been out of the country for more than 6 months, to obtain a visa in such a short time frame. I've been informed, however, this morning that a representative of the claimant, together with the claimant's Russian counsel, are attending the immigration department and are trying to sort out all what is needed to be done in order to obtain a visa. We just wanted to update the court as to the recent development and file this application for a provisional order in the event that it will not be possible for Mr. Krayushkin to obtain a visa
I see your application. Let's hear. So I'm proposing to the defendant to deal with the application one by one. So let's hear from the defendant about the video appearing application first. Then we'll move to the second application. Please.
Yes, Your Honor, thank you. We received this application extremely late, and we say there's actually no basis at all for it. What we've been told by the HR department of our client, MAG, is that a visa can be obtained within a very short time indeed, and we're told that a visa can be obtained within 3 days of application. And in fact, this reason, the visa reason, has really only been put forward since the other side has seen the witness statement of Mr. Graham, our client's instructing solicitor who's with me here today. And we say this is an afterthought, the actual reason, and in fact it's not a good reason at all. Of course, if a party cannot physically attend a court, then it's appropriate to allow video link evidence. What we have here is we have a claimant who's seeking to obtain substantial damages from our client. Their main witness is Mr. Krayushkin, and in fact, until the reply evidence, he was the only witness of the claimants. And now what we're being told is that he may not even attend and be present in the jurisdiction, and we say that's quite inappropriate. What we say is, if there is a problem with the visa, which for the reasons we've said, we doubt very much, then what the proper course should be is that the other side should provide witness statement evidence that they can't obtain a visa nearer to the trial. We say there's plenty of time for them to get the visa. Mr. Krayushkin should attend if he wants to assert and continue to assert his case. And then that's our argument, sir, in a nutshell, Your Honor.
Well, I see your point, but there is, two difficult points in regard with your defense. The first one, when you ask the claimant to provide a reason why they cannot get a visa to enter into Dubai in a short time, I think the lack of visa itself is an evidence that he didn't have visa. It would be very difficult, I guess, to anyone to get into immigration and say, why are you not giving me a visa? Usually, that process is a bit complicated, I guess. But if someone doesn't have a visa, so it's a negative thing, and when you it will be difficult to ask them to prove the negative thing, isn't it? So that's one thing. And the other problem is that you saying this visa can be issued in 3 working days or something like that. But again, I don't want to ask you to prove that statement as well, but it can be difficult. What I can see, the claimant is trying to protect the trial, but as they said, they are in the process of issuing a visa for the claimant to enter into the country. And if it doesn't work, in case it doesn't work, so the permission for video link appearing would just keep the trial alive, and at least to keep their evidence alive as well. I don't think it's late. First of all, I don't really think it's late, because you, as we, aware of the criminal proceeding, the previous criminal proceeding which just released last week. The other thing, the claimant's efforts to protect the trial, to protect as well their evidence, and they still putting it as an option. So the claimant might be here. If he's here, then there is no need for the video link. If he's not here, then the video link would be unnecessary. What do you think?
Your Honour, we understand the position that the court's taking. One question for the other side is, where is Mr. Krayushkin resident? I have seen on the internet some reference to him being in London. I'm not sure exactly which country he's coming from, because that may well affect whether or not he needs a visa and the time that would take to obtain. So that's a first issue. We take your point in relation to the proving a negative. I mean, to then perhaps make another proposal, and that is that the claimant makes the best endeavours to procure a proper visa so that Mr. Krayushkin can attend in person.
Yes.
Those are 2 points.
I understand that the claimant is currently in Russia, is in Mr. Perusian, is in Moscow, and if a video link is necessary, he would be given evidence from Moscow. Also, with respect to the visa, I understand that the problem is due to the fact that Mr. Perusian has been out of the country for more than 6 months, and Mr. Perusian is doing his best to come to Dubai. In fact, I was informed literally 15 minutes prior to this conference that Mr. Perusian, Russian lawyer, is having a meeting at the immigration department this morning. So we should be able to update the court probably even this afternoon. And if there are any problems, of course, we will submit a witness statement.
Yes, Mr. Brown. Mr. Graham. What she said.
We have no further
the
point.
witness currently in, have you heard
Yes.
her?
Yes, we have. Yes, I mean that's it sounds like matters are progressing, and we do wonder why this was done so late. But in fact, if matters are being taken care of today, then that's obviously positive news, and it sounds like things may turn out okay. So it sounds like also that this application may not really be necessary, but we're in the court's hands, and we've made our points.
Yeah, that's right. I understand that. I will decide this later with the rest of the applications. We'll move now to hear from you. I will allow you to present your applications. You can start with,
I'm grateful.
with either of them. I'm okay with that.
I'm going to start with the application to amend the defence and counterclaim. We sent. You'll appreciate that my instructing solicitors, Mayor Brown International, are relatively new to the case, and they took over the case in March of this year. Your Honour, just before I begin, I just want to make sure you have my skeleton argument, I assume,
Right.
that was sent to the court.
Yeah.
So Mayor Brown are new to this case, and of course we would say that it's appropriate for them to have had some time to get to grips with it. And it's not unusual, we submit, for a law firm to look at things afresh and require some time, first of all, to assess the case, and then if necessary to make amendments. I mean, the case was commenced some time ago, and of course, in the usual course, these things and issues become finessed and issues become clarified as matters progress. And in fact, that's what's happened here. And what's happened is Mayor Brown has looked at the case with counsel, of course, and thought it necessary to make, we say, very few, we've listed them here in my skeleton argument at paragraph 7, very few amendments to really clarify the position, and also to bring it in line with the agreed list of issues, which Your Honour will also have, and which we say would benefit both the court and the claimant as well. Surprisingly, the claimant has resisted and wrote to us as soon as we sent these draft amendments on the 21st of April. They wrote back to us saying, no, we're not accepting any of these amendments apart from the one at paragraph 20. But everything else is not agreed. And we say that's unfortunate and unhelpful and also unnecessary. Of course, it didn't explain at all why they're resisting these amendments. What they have done since is put in a statement with various cases which essentially say that late amendments should be considered very carefully, and the court shouldn't just simply allow late amendments. And we have quite a lot to say about the cases that they put in, because actually they're not relevant to this case at all. But before I take you to those, with Your Honour's permission, I'd like to just take you through the several amendments, the small amendments that we'd like to make, and just explain the rationale for those by reference to the agreed list of issues, if I may. So you have the amendments at tab 7 of the bundle in front of you. And the first one it's at 7 Roman numeral 2. And the first one is at paragraph 8. And it's 8 Roman numeral 1.
Yes.
And then there's also the similar amendment at 14. And what this amendment does, essentially, is go to the question of the meaning of Clause 6 of the tenancy agreement. And this, I can take your honour to it, but you may recall, because this has been before you before, it's the clause which says that the permitted use is a restaurant of the premises, is a restaurant and bar. And the question for the court, of course, is does that clause impose an obligation on the defendant to obtain and procure the change of use through the DIFC? What is the meaning of that provision? And what we say is that actually that issue, of course, is an important one for the court, but is already preempted by issue number 7 on the agreed list of issues. And all we're doing by this amendment is making it clear that that is an issue which we would like the court to determine, which the court ought to determine in any event. So that's the first amendment, as it were. Looking at the second group of amendments, I'm now at paragraph 7.2 of the skeleton argument. The second amendment you'll find on paragraph 8, Roman numeral 6, and this makes reference to clauses 19 and 36. So these are provisions of the tenancy agreement which deal with termination. What clause 19 says is that you have to terminate on the anniversary date with 2 months' notice, and clause 36 talks about giving 2 months' notice. And the issue that we simply want to make sure that the court determines is how clause 36 operates. In other words, is it possible for the claimant to simply give 2 months' notice at any point during the period of the contract, or can they only give notice which ends on the anniversary date? And we say that the latter construction is the correct construction. And again, these issues are issues which the court will have to determine, we say, in any event. If one looks at the agreed list of issues, issue 11 and issue 12, one sees that straight away. So issue 11, for example, does the claimant have the right to terminate the tenancy contract at any time by giving 2 months' notice? That issue is already before the court. And what we want to do is simply make clear that the court needs to look at clause 36 in the context of the agreement as a whole, and in particular clause 19. We don't want that to come as a surprise to the claimant. So again, just another legal issue. The third set of amendments, which I referred to at paragraph 7.3 of my skeleton argument, involves the amendment of paragraph 15, which really deals with the nature of the agreement or understanding that the defendant would assist the claimant to procure the change of use by the DIFC. And again, it's an issue which the court clearly needs to determine. Is this a contractually binding agreement? And if so, where does it come from? Is it a freestanding agreement? What is the extent of that? What are the terms of that agreement? Are there any limitations to that agreement? All these things are issues, we say, which are before the court in any event. And again, we refer here to issues 2 and 3 and 16 of the agreed list of issues. So, for example, agreed list of issue 2 is, did the defendant have an obligation to deliver a space fit for restaurant and bar use regardless of the amount of fee imposed by the DIFC? So in order to determine that issue, the court needs to look at this very issue that we're putting forward here, and that is, what is the remit, what is the extent of the defendant's duty, if in fact there is a duty. So these are issues we say, again, the court has to deal with in any event. 7.4 my skeleton argument refers to paragraph 20, which has been agreed, so we don't really need to look at that. Paragraph 7.5 really follows on from the other amendments, proposed amendments, and really go to what are the consequences of those amendments. So in other words, if in fact, for example, the court finds that the claimant cannot terminate an agreement apart from on an anniversary date, then what's the effect of that? And that's what 7.5 does. So those are consequential amendments. And then we have paragraph 7.6 of my skeleton argument, a reference to paragraph 48.4 of the amended defence. And 48.4 deals with the earlier case that came before Your Honour, which was a claim for specific performance by the claimant for the defendant to procure the change of use from the DIFC. And a question, of course, arises as to what is the status and effect of Your Honour's order. Because Your Honour ordered that our client procure that use, and our client went ahead and did that, and in compliance with your order. And the question is does that order have res judicata effect? In other words, does that mean that we cannot now argue that clause 6 of the tenancy agreement does not impose a duty by itself on our client to procure the use and pay for the DIFC? Is that issue open for us to take? Now, the claimant themselves, at paragraph 39 of their particulars of claim, rely on Your Honour's order to say it's res judicata, that issue is all over, and the only issue for the court now in relation to that particular matter is the amount of damages that the defendant needs to pay. And what we say is that is not res judicata, and there is obviously case law in relation to that which the court will need to assess. But in any event, to the extent that the claimant did not pursue a damages claim in those proceedings in CFI 040/2014, would now be an abuse of process to issue completely new proceedings, fresh proceedings, and pursue a damages claim. As a matter of law, that would, we say, be an abuse of process. Now, we have at paragraph 48.4, before the amendment, flagged up this issue, which is clearly, we say, the way it was drafted, it's clearly an issue which goes to the abuse of process. And all we've done really is clarify and use the term abuse of process and clarified that's exactly what this paragraph is about. It's an abuse of process argument. And of course we make the point that in fact it's not the order of CFI 040/2014 is not res judicata, and that's an issue, as I say, that the claimants themselves have raised. So these, of course, are issues which the court, again, will have to determine in any event. And all we're doing is really clarifying what's there. And if one looks at the agreed list of issues at issue 10, one sees that issue is there already in black and white before the court. Does the claimant have the right to claim damages in this case in light of the fact that it reserved its right to file a separate action for damages in its specific performance case, CFI 040/2014? And obviously to determine that issue, the court needs to determine the status of that earlier case and the earlier order, and of course whether it's an abuse of process for the claimant to pursue a damages claim now. So again, there's nothing particularly new. The next amendments, and I'm looking now at paragraph 7.7 of my skeleton argument, again are really just consequential on the earlier amendments that we've looked at, so again nothing new. And then the final group of amendments one finds at paragraph 67 of the amended draft. And these all go to the standard issues in breach of contract cases of causation and loss and mitigation. Because of course the claimant can only claim and only succeed on its claim for breach of contract if it can show that any damages were caused by the defendant. It has to prove its loss, which we say has completely failed to do for reasons that will become apparent at the trial. And we say, of course, it's a duty on the defendant to mitigate its loss. So in the case of the DIFC application, of course, if the defendant didn't pay the DIFC, when it could have done, even if it was a duty on us to pay the DIFC, then that's a clear failure to mitigate. And those issues of causation, loss and mitigation have to be, we say, as a matter of course, before the court in any event. What we've done by setting it out is simply help the claimant to realise that those issues are going to need to be dealt with in detail. So again, just to summarise, there really is only 4 areas which we're asking the court to allow amendments in relation to. They're all legal issues. So area number one is simply the construction of the tenancy agreement, and in particular in relation to clauses 6, 19 and 36. Issue number 2 is really the basis of the assistance that the defendant was offering the claimant, and again we say that's not new. Issue number 3 is the effect and the status of the order made by Your Honour in the case of CFI 040214. And the issue number 4, which we say the court has to deal with in any event, is issues of causation, loss and mitigation. We say for all those reasons, what the claimant should have done is, as the rules say, the rules of the Dubai Court at Rule 1812, is a party should consent to a proposed amendment unless he has substantial grounds for objecting. The grounds can't just be minor grounds or small grounds or little complaints. They have to be substantial. We've seen nothing in the way of substantial grounds. And in fact, what the claimant says is, this is all very late. And we accept that, Your Honour, and we accept that in an ideal world these amendments or clarifications should have been applied for earlier. And we apologise to the court and to the claimant for that. However, this is not a case where it's so late that it causes any prejudice whatsoever to the claimant. They're purely legal matters. We're not relying on any further evidence other than that which is before the court already. And in fact, we say there's nothing that the claimant needs to do other than deny these points if in fact the claimant seeks to deny them. And Your Honour will have 3 cases that the claimant has put before you to try and show you that late amendments shouldn't be allowed. And even a cursory reading of these cases shows that actually in all of them, what was happening was that parties were bringing amendments not only late, but actually during trial or once trial had started. I don't know whether you have these 3 authorities in front of you, but I'll take you to them very briefly just to clarify this point, because they really highlight the weakness of the claimant's position, we say.
Yes.
If you look at the worldwide case, you can see on the first page, and the very first line is under the section headed Introduction. This is an application for leave to appeal 3 orders made by Morbic. The first order was made on the 12th, and the second and third on the 17th. Those dates were the 4th and 6th days of a trial in the commercial court, which has been fixed to start and did start on the 9th of November 1998. The time estimate for the trial had been 20 days when it was fixed, and the estimate by the commencement was 24 days. So I don't even need to take you further, but you can see that what this situation dealt with was a situation where there was a very, very long trial indeed, 20 days or 24 days, and that actually once trial had started on the 4th and 6th days, then there was an application for leave to amend. And it's not surprising that in such a situation the court would think very carefully before deciding whether or not to allow an amendment. So that's that case. Then you have the Hanan George Harb case versus HARH Prince Abdulaziz bin Fahid bin Abdulaziz. And you can see already what's going on in this case, because if one looks at paragraph 2, one sees that this is the first direct day of a trial where the claimant claims the contractual agreement was entered into between her and the defendant in June 2003. And again, if one turns over to page 4, one gets a little flavour of what's going on in this case. At ruling 1, the section headed ruling 2, at page 4. This is the first day of the trial in this action. Accordingly, as is usual in cases, I have an application to re-amend. And it's interesting that the judge says, as is usual in cases, because we say that it isn't unusual to apply for amendments. But of course, in that case, it was a very late amendment indeed. Once trial had started. Now, again, looking at the last case, which
in these 2 cases, the amendment allowed or rejected?
I think they're rejected in these 2 cases. But the court, we should point out that the court had to think very carefully about it before rejecting them, and acknowledged, in fact, that actually the issue for the court is whether justice can be done, and really striking a balance between any prejudice and making sure that justice is done. And we say that that's a right. Obviously, those are right concerns, those are correct concerns, and we refer to the Cobbled case, the Court of Appeal case, in our skeleton argument. But what we say is these cases don't really help the court at all because they deal with amendments after trial. Just for completeness, there's the final case of Parminder Singh Haya, which you have, the 2012 case. If one looks at paragraph 5, for example, at the trial, we are told that the evidence started on the afternoon of the first day, which is a Monday, and continued until the end of the morning on the fifth day, which was a Friday. The closing submissions then began, and when Mr. Sefton Smith, who appears on this appeal and appeared at the trial for the respondent, started his submissions, the judge intervened to express concerns that he had about whether the defendant had understood the transaction into which he had entered in the trust deed. In other words, here again, you've got amendments, not only during trial, but really in closing, and only as a result of something that the judge has said. So for those reasons, we say these cases don't assist, Your Honour, at all. So for all the reasons that we've mentioned, with the court, we respectfully ask the court to permit the proposed amendments and to allow justice to be done in this case, and hopefully the amendments should be helpful to the claimant as well. I don't know whether you want to hear from the other side on this application before I make the other application for security.
No, I'm okay with that. If I may summarize your application, you're saying it's a bit late, but it's not too late, as you're saying. The cases showed that application of this kind can be put before a court at any stage, even, as you said, sometimes during the closing submissions. That's one thing. And then you're saying another reason for that, because the change for representation of the parties, you have another view of how to put the case, and in any way, all of what you putting in your amendment is something already exists in the list of issues, so that the claimant is aware of, so you're not taking your opponent by surprise at all. Is that right?
Your Honour, I couldn't have summarised it better myself. That's completely correct. The only thing I would add to that summary is that we also say these matters are all legal issues. They don't rely on evidence at all. And in fact, the cases, of course, only are appeal cases. They're not cases of initial cases where the court's exercising its initial discretion. But Your Honour's summary is perfect, apart from those points.
And
yes.
Do you mind, in case if this application allowed, the claimant is be given the chance to respond properly for this in both whether the skeleton argument or writing closing submission as well?
Absolutely. I mean, we say these, as I mentioned before, I indicated that we say that actually the claimant doesn't necessarily need to respond at all if it doesn't wish to, because we understand what their case is on all these points, their legal points, and we understand their position. If they want to, there are several weeks still for them to make these small amendments. There are opportunities in the skeleton argument. You would see the trial timetable as well, which has been agreed. There's opening submissions, there are closing submissions, there's 2 or 3 days of evidence. There's ample opportunity for the claimant to deal with all these points, and in fact needs to do so to really to succeed on their case. I'm also being told by my instructing solicitor just to mention that, of course, there's a Court of Appeal authority for the principles that we're relying on in relation to justice being done and the overriding objective as well. That's just for completeness.
Right, I hear from you. Yes, we'll move now to hear from the claimant.
Thank you. Well, I would like to make a few points. First of all, the amendments are too late at this stage of the proceedings. There are not few amendments to clarify the position, as the respondent has just stated, and there are not all legal issues. I'm going to address this point one by one. First of all, the claimants object to this application, which has been filed at such a late stage of the is extremely late since it has been made 2 working days prior to the pretrial conference and less than 3 weeks prior to the trial. And there is no reason why the claimant, why the defendant could not have been sought this amendment earlier. And the factual background shows why these amendments are so late. And this is demonstrated also by the witness statement of Mr. Neimer, which is a part of the bundle and which was submitted in support of a previous application filed by the defendant in this case to extend the deadline to submit witness statement and to amend the pleadings if necessary. The witness statement of the defendant's representative shows that the new counsel, Mayor Brown, was hired on or about February 2016. The defendant met with the new counsel in mid-March 2015, and the amendments at the time were discussed. In fact, Mr. Neimer, in his second witness statement, at paragraph 15, states that when the new counsel they had identified a number of issues where they felt that the proceedings served in this case needed to be redrafted. Therefore, there is no justifiable reason why the amendment could not have been sought and submitted to the court on March 24, when in fact the defendant had already made a previous application to amend the pleading. No proposed amendment was given to the claimant, and therefore the claimant didn't have any opportunity.
So would you repeat that? There is a previous application for amendment being put before this court?
There is a previous application to extend the deadline to submit witness statement and, if necessary, to amend the defense. However, at the time, the defendant didn't submit the proposed amendment. Therefore, the claimant no amendment was provided, and by order of Judicial Officer
Moheri.
the application was rejected.
So the application dealt with the only witness statements, isn't it?
Yes, but the judicial officer actually gave the defendant an extension for the extension to submit the statement.
Right.
So,
Yes.
in addition, even if the defendant believes that they have just been retained, when the previous application was filed, we understand that Mr. Ray had been on the case for at least approximately 1 month, and that his colleague, Mr. Praga, was familiar with it, should have been familiar with the case, because he was previously working with Baker McKenzie, which has been represented the defendant in this case since the very beginning until the change of legal representative.
He's not a teacher, see?
So that's all about it's late. Okay?
Yes.
So will you go to the jump to other point?
Yes. To also make the point that the claimant had a very little opportunity to consider this amendment, so considering the short time frame it has had from the filing of the application or when the defendant provided the amendment until today. We also object to the defendant's position that the amendments are just not two amendments, they are amendments to 11 which raise legal arguments, and particularly concerning is paragraph 67,
67.
which raises some substantial factual assertions which are vague and unparticularized, and we submit your honor with current evidence, statement, and possible even further discovery. Paragraph 67, the defendant states opening of the record bar that was made in an event because of the claimant's own actions and requirements.
it for you this way. Well, in case the defendant proposed to withdraw 67 amendment, would you agree to the rest of the amendment?
Well, Your Honor, we have already agreed to paragraph 20.
And I'm saying 67 versus all of the other changes. I haven't heard from the defendant, but I would just want to hear from you. We've seen that most of the changes as really matches the list of issues proposed by both parties.
Yes, Your Honor, but for example,
Oh, just tell me if you're willing to accept that kind of deal, or I will refer to the defendant to say something.
we accept it, and paragraph 67 is struck out, and the rest is allowed to continue. Our position is that addressing a sentence would require opportunity to properly reply to the amendments, because we need to take the plaintiff's instruction, and we need time to consider the amendments. These are new arguments. Even if the defendants of these are legal arguments, still we have to
How are you proposing to deal with that? How you will tackle this kind of amendment?
submit a reply.
Okay, then reply. Apart from the skeleton,
Apart from skeletons,
then
and then we would have to submit skeletons, and this would not be a problem if the trial was scheduled on answer today, but during the legal trial preparation, during the legal preparing trial bundles, we have been delayed because of the vagueness of this legal application.
this is not a real acceptance. This is not a real acceptance of this amendment, because if you will accept it, it should be like melted in the rest of the proceeding. You should be able to deal with it in your skeleton argument. And then I'm also offering you the right for a written closing submission to deal with them, with the rest of the case, or even or particularly with this kind of issues, in your closing submission, in case the court will take it into consideration. That,
I understand.
let's hear from the defendant first. They might not just agree for the
I
judge.
think we would agree to.
Yeah, I think she's shown a willingness to agree to my proposal. I just want to hear from you. Defendant.
Yes, we're grateful for that, and of course we don't want to stifle any right of response or to deal with these matters that the claimant has. In fact, we would like them to deal with it and these points. And in relation to 67, the points where the paragraph starts in particular, and there are various examples, all these examples are taken from matters which have arisen and are shown from the disclosure materials. Now, I don't have all of those. I'm not in a position really to take you through each one in particular.
You didn't have to take me through, but if you believe it's already related, it's already discussed, it's already like an agreed list of issues and been dealt with in the rest of submissions and can be dealt with in scheduled arguments, then I think I don't see any problem you agreeing to the proposal.
Your Honour, we're not relying on a single
application.
Yes, well, we're not relying on any new evidence whatsoever. If Your Honour wants to strike out the words "in particular" into the end of the word "defendant," so in other words, where it says the paragraph saying starting the opening and then the DAFC application, and take those paragraphs out, in other words, the examples, then we're happy to have those removed and to remove those. We do say that where the paragraph which starts the defendant cannot, as a matter of law, be responsible for the damage arising from the claimant's representative's absence from the jurisdiction after having presented checks that bounce, that should stay in. That really comes from Mr. Kroyushkin's statement, where he says that the fact that he's not been in the jurisdiction because of the criminal proceedings has destroyed his business. And what we say about that is that that's got nothing to do with this particular case. And in any event, he can't rely on his own his own criminal proceedings to make this point. But we're happy to remove the paragraph before, which says the DAFC application did not prevent, and the one before that starting the opening. So from the words in particular until the words the defendant cannot as a matter of law, we'll take those out quite happily.
So that says you would keep the first and last sentence of this amendment of 67 amendment. Is that right?
Yes, because the first one just deals with the issue of causation, and it simply the simple point is that to prove its case, the claimant has to prove that the loss was caused, and that point we say should stand. And the last point is we say is just a point about the which is a follow-on point about the effect of the criminal proceedings, which the claimant in their latest evidence says that resulted in the loss which is being sought. So that we should say should stay in. And then there's a final point. The claimant's loss is already substantiated. Of course, we can make that point anyway, and not being reasonably mitigated. Again, just a simple legal point. But we're happy to take out the words from in particular until the words legal responsibility of the defendant.
Yes.
Yes. And obviously, and I'm being yes.
Yeah. Clement, you okay with the proposal?
Yes, Your Honor. I think we are okay with that. However, just a clarification, the last sentence, the claimant's alleged losses are also in substance obviously insulated and have not been reasonably mitigated.
Oh, you mean the third line from the bottom of that paragraph?
Yes, Your Honor. We believe.
Yes. Defendant, she was the last.
We strongly object to that. There's a very important reason behind the claimant's assertion that should go out, and that's because there's an obvious mitigation point, and this goes to substantial injustice. What the claimant is claiming is that they should have all the damages resulting from an alleged delay in our applying to the DAFC for change of use. And what we're saying in terms of mitigation, one of the obvious points which jumps out from this case is that at any point in time that the claimant was not happy with the progress being made on the change of use, they could have gone to the DAFC and written a cheque. And we say as a matter of law, in terms of mitigation, that's exactly what they should have done if in fact they had a problem. And we'd say it'd be quite unjust for a court to say, I'm not going to listen to that particular issue. It's a legal point arising from the facts. It causes no prejudice to the claimants. And the claimants know that that point is actually unarguable on their side. So we say it should remain.
Your Honor, I apologize, but we disagree because mediation is not a legal issue. The defendant is going to have to prove that it has indeed mitigated the damages, and to prove that it has mitigated the damages, it's going to have to submit a new witness statement, which is going to go specifically to the point of mitigation, which was not argued before.
Well, I have not gone through the whole of the evidence and see if this point's covered or not. Really, honestly, I have not gone through that. But I'll leave it to the defendant. This is the last chance. If you want to withdraw this last line, and then we allow the application, or you just leave it to the discretion of the court to deal with the whole application. It's up to you now. I want to hear last answer.
Okay. Well, my instructions are that we are grateful to the concessions that have been made by the claimant and for the way that the court's approached this, and we're grateful for that. On that basis, we don't want to lose any chance of having these amendments. We say they are important. We will, just to flag up, we are happy for this to go if the court insists that that's what happens. Otherwise, we fall back on the mercy of the court. We will.
The court suggests.
Yes. Okay. I'm grateful, Your Honour. We don't want to take a risk of the court not allowing the amendment. We do say the mitigation point is an extremely important point. Given that my learned friend just made a concession that she has to prove mitigation, and we say that is true as a matter of law, and we will be relying on that point regardless of what the court decides.
If you just take it this way, if you think it's covered by your original defense, if it's covered by the list of issues, and it's included in the evidence, then you can deal with it during the trial. So it's not a big deal. I'm just following your proposal when you said it's not really new.
Yes.
You know. Yeah.
Yes, we're happy to accept that, and again, we will be relying on the concession made by the claimant. We can strike that line, and we're happy to do the deal, as it were. Thank you, Your Honour.
And in return, we would give the claimant the opportunity to reply on this and the closing submissions instead of making any amendment now to their statement of case.
Yes.
We'll move now to your last application.
Yeah, so this is an application for security for costs, and again, we accept that this application is later than what may be appropriate for many types of applications of this sort.
I'm grateful you understand that.
Yes, we do, but it may just help Your Honour just to explain a little bit why we come to this position. Obviously, now, just post PTR and a trial of this sort, this is where the costs mount the most, and they're about to for both sides. So that's point one. And the second point is this application that's before Your Honour today for evidence to be given by video link, which in many respects seems like an innocuous, innocent application, but we say is extremely troubling for the reasons that we've already highlighted, and that is Mr. Krayushkin is effectively the person, the client, the claimant, the person standing behind the claimant, which we say is a mere shell company. And Mr. Krayushkin is not in the jurisdiction of the DFC. And what, of course, he sought to do was say, look, I'm not going to attend the DFC. Now, originally he said this is because of the criminal proceedings, and he doesn't want to attend and risk whatever the consequences of those proceedings would be. However, Mr. Graham clarified that these criminal proceedings were over, and therefore Mr. Krayushkin should attend in person to give video link evidence. Now, what the other side should have done immediately at that point is say, well, of course that's the case, we want him to attend, it's important, he's the one making his case, he should attend, but they didn't do that, and in fact they didn't explain why Mr. Krayushkin couldn't attend. And what happens is Mr. Graham puts in his skeleton argument, explaining the concerns and saying, look, Mr. Krayushkin has an apparent aversion to the jurisdiction of the DAFC. And then suddenly, we talk about late applications, suddenly we get a very late application from the other side saying, well, there may be visa issues, and that's the reason why. And we say, so we're in a situation, if one then steps back, where we have a claimant where we have absolutely no evidence whatsoever on the state of their finances, or who their shareholders are, or anything. We just have a company which looks on its face to be a mere shell company, as Mr. Graham says. The other side haven't at all provided any evidence whatsoever as to what this company is, as to what its assets are, as to who stands behind it. So we have nothing, no evidence at all, and yet we have Mr. Krayushkin, the person who we say stands behind the company, who's resisting, or at least flagging up now, the fact that he may not attend the hearing at all. And given that, and given the amount of expenses that are still to be incurred, and incidentally those have been, we can sort of estimate those with some degree of confidence, because costs have been flagged up within the PTRs at tab 4. But we're now in the situation where we're going to incur costs. And so if you look at paragraph 12 of my skeleton argument, you can see these arguments set out here, that the claimant may well be a company established for the sole purpose of the restaurant project. It's a shell company. Mr. Graham wrote to the other side. And at tab 8, actually, which is worth going and having a look at this, at tab 8 of the bundle, one sees the correspondence from Mr. Graham to the other side. There are two letters that are presented here, simply asking for a clarification as to the position in relation to the claimant, and asking for a proposal in relation to security for costs. What we have, so the letter from the 19th of April, in advance of the pre-trial review, we're spending considerable sums preparing for the trial. We understand your client has no ongoing presence or assets in Dubai. Is that correct? We know very little about your client, other than it's failed to pay sums due for rent, and that checks have issued which have bounced. And we then sent a follow-on letter on the 20th. We don't hear anything from the claimant. We refer to our letter of the 19th, we ask you that you respond by first thing today so that we could issue the application in good time to be heard at the pre-trial review. And as far as I'm aware, I'm just going to confirm, no response at all to these letters. And in fact, astonishingly, we have no evidence. And once again, the claimants put in the bundle various cases which they seek to rely on. And this time there's a case, I think, there's one called Crabtree, and there's one called Spy Academy. And again, these cases are not cases where there's no evidence whatsoever of the claimant's assets. And these are also cases where one of the issues, at least in one of them, is that the damage allegedly caused by the defendant would stifle the claim of the claimant. And there's no evidence at all that that's the situation here. In fact, what the other side have said is that there are some assets in Dubai, and that's it. That's as far as we know. So it's not a case of stifling, and the court shouldn't treat it like that. So it is an unusual, it is as we say, a later than perhaps should have been type application. But even though we say the situation is extremely unusual, given the absence of any evidence whatsoever, and the danger that we may go through this whole process and actually not be able to secure repayment of our costs because they've not been secured. And we say some security, and obviously we're in the hands of the court as to that amount, should be provided at this juncture.
They say there's no evidence with the defendant's pre-trial checklist.
Yes. Just bring one last point, is that they say there's no evidence of costs. But again, the defendant's pre-trial checklist at tab 4 does explain that €840,000 have been spent. And we would say that the same, and theirs is 856, is slightly higher. So we're saying that sort of amount is likely to be spent again going forward now in this period of very heavy work indeed.
Is that dirham or euro, you said?
Those are euros.
No.
They're dirhams. I've been corrected.
Right. Well, yes.
Do you want to? Those are my initial points.
Yeah. I read your submission on this, and I just heard you. In this application, I will hear from the claimant, then I will refer back to you as I have a very important question after I hear from the claimant. Yes, please. Would the defendant keep the mic away now for a minute, please? Yes.
Yes, pursuant to Rule 2599, an application for security for cost must set out as a grounds on which security is sought and any factors relevant to the exercise of the court discretion, including, with regard to costs already incurred, the elements described in Part 3835, and with regards to anticipated future costs, an estimate calculated by reference to the elements described again in Part 3835. Our position was that the defendant should have submitted a statement of cost and not just an estimate of the cost incurred so far. In this respect, we said that the application was procedurally defective. With respect to the other points, we are not saying that the claimant has enough assets to pay costs in the amount of 1 million. The claimant, first of all, the defendant has not proved that 1 million is the proper amount of security in this case. But in any event, the claimant's admission is that it would be unjust under the circumstances of this case to make an order for security for cost. Pursuant to Rule 2511, the court may make an order for security for cost if it is satisfied, having regard to all the circumstances of the case, that it is just to make such an order. And one or more of the conditions in Rule 25102 applies, or an enactment permits the court to require security for cost. This means that even if it is proved that the claimant doesn't have sufficient assets, still the court is outperformed the expected revenues for that restaurant. So we submit that the claimant's financial situation has been caused by the defendant's action. Therefore, it would be unjust.
Well, Mr. Mutalabu, from I understand what you just said, your client in a real hardship, financial hardship, but it's caused by the defendant. That's what you're saying. So first of all, you admitting he is in a financial hardship. Is that right? The second thing you're saying, that caused by the defendants, okay? So I would take the first point, because no one argued that, but when it's caused by the defendant, that is a fully argued by the defendant, because there is a case, there is a court going to determine whether that kind of hardship was caused by the defendant or not. So there is still no final decision whether the defendant has caused your claimant hardship. So is this what you're trying to say for now? I mean, I have another question, Mary. Yes.
Sorry, I don't have detailed information about the financial situation of the claimant. The claimant is a DIRC company, and it has certain assets in Dubai. There is a question as to whether the value, the actual value of these assets is sufficient to cover the cost. The fact is that the claimant has assets. These assets are all the items, the equipment, the furniture that the defendant, that the claimant purchased to run the restaurant. These are currently, I understand, in storage in Dubai. The question is, the issue is that these assets have certain book value. We don't know what's going to be the realization value of these assets if are going to be resolved. We understand that, I didn't have detailed instruction from the client. We understand that certain assets were items were custom made, but others were very expensive items that are just still sitting in storage right now.
There is any amount in your mind which your client can deposit into the court as security of cost?
Well, Your Honor, this is another issue.
I'm not saying the 1 million, but
I need to take instructions with respect to this, but the other point I wanted to bring up with respect to the fact that it would be unjust to grant security for costs is that the defendant in this case has a counterclaim. So in the event the court grants security for costs and security is not paid by the claimant and therefore the claimant's claim is dismissed, the same issues would be litigated by when the defendant prosecutes its counterclaim, and we would be in a situation where the claimant would not be able to pursue its claim, but would still litigating the defendant's counterclaim.
would the counterclaim still alive if you lose your original claim? I guess not. Anyway, okay, I'll refer to the defendant and I'll come back to you.
Thank you. We heard a moment ago that the claimant claims to be in financial hardship, and then we're told that this is due to our actions. And then it turns out that actually my own friend Ms. Montalbano doesn't have detailed financial information, doesn't have instructions. And then we're told that the defendant has certain assets in Dubai. We've never been told what they are until now. We're now told that they comprise equipment and furniture and storage. All this is new, and this is all being given, we say, by way of evidence given by counsel. And we say it's an extraordinary set of circumstances. In the usual course, a security application is put in, and sometimes it is done at short notice. The other side will then provide information that either say, here's our financial accounts, and you can see we've got lots of assets, you don't need to give security. Or they'll say, here's our financial accounts, you can see we've got no money, and you can see the money has gone because it's being paid to you, and therefore our claim will be stifled. But here we have a situation where evidence is being given on the hoof, at the hearing with no evidence at all, and they've had 5 days to put this evidence in. And we say it's not satisfactory, and in fact, it simply supports the fact that security is needed here, particularly in this case. Now, in relation to the issue of the counterclaim issue is really, we say, irrelevant. There are different issues at stake. Our issue, in terms of our claim, one of them, as specified, is the fact that we say the termination that was given was wrongful, that there was no basis for that termination, and therefore we're entitled to our rental payments. What the other side are asking for is damages, which we say are particularly unparticularized and hazy, but in relation to alleged delays caused by the change of use application, the presenting the premises without, not in a state of shell and core, allegedly, and an alleged delay in providing drawings of the premises. So it's a different claim and a different counterclaim. And actually, one of the authorities put in by the claimant, called Crabtree, at page 5, does explain this point, that actually the counterclaim often doesn't really make a difference. And it says this: where the costs of both are coincident, it seems that the mere fact that the counterclaim exceeds the claim is not a reason for not granting security. In that particular case, there was a bizarre situation because the plaintiff's claim was stayed. So actually the plaintiff was considered to really be the real defendant, which is why the counterclaim mattered in that case. In other cases it doesn't matter, and we say in this particular case it's irrelevant. So it's not an argument at all. The only other issue that my learned friend raises is one of procedure in relation to evidence of costs. And we pointed the court to the PTRs and the estimate. To the extent that a further clarification or estimate is needed, then this can be provided forthwith. The other side are going to have to provide information to the court in relation to their application for video link evidence. And we could put in, with the court's permission, a very, very short statement of estimated costs. Alternatively, and we say a more pragmatic approach, would simply for a reasonable amount, not an excessive, but a reasonable amount, to be paid by way of security. And we understand, of course, that Ms. Montalbano said she was going to be taking instructions, so we'd be interested to hear what that amount would be, unless Your Honour has further questions.
Yes, Mr. Harris. Yeah, I think you put your points in a very clear way, and I think so far your argument is more favorable to Ms. Montalbano one. But I have a very important question for you. Why is just now you put this application? Why it's now? The case been put for a long time. It's been defended, but evidence has been put before court. We just a couple of days before the trial. What I'm saying, you already incurred most of your costs. What you trying to protect now? What's behind this? This case even can't be decided on paper now because it's bleeded. Everything there. We just looking forward for the skeleton argument and hearing the case, then issuing the judgment. So what's the point? What interest is you protecting now? Even if all of what you have said is right, even if there is no evidence of the credit of the claimant himself, but what's the point now? You already incurred most of the costs.
Yes. There are a number of responses to that, Your Honour. I mean, the first point, and this is actually a point of clarification. My client, my instructing solicitors, Mayor Brown, only came on board in March 2016, and it's true that there was some people who came over from the former firm, but they weren't litigators. So it's only at March 2016 where my instructor solicitor takes carriage and responsibility for this case. At that point, as we've said previously, it's right for them to have an opportunity to assess how the land lies and to see what needs doing. And that's actually quite an important point that I believe the other side have failed to pick up. But in addition to that, it's true that substantial costs have already been incurred, and we say it would have been right for the other side, for our side, to apply earlier for security for costs. However, there is still 3 weeks to trial, and we do say that in the normal course, when parties are now working towards trial, this is where the amount of time increases exponentially. So there are still substantial costs to be had. This isn't purely tactical. There are costs to have, and we don't say, and we wouldn't want to risk the issue being just heard on the papers, although we say that one can see the problem, the difficulties for the claimant, but we would, the claimant wants to take this to trial, and therefore we're going to have to put the effort in to prepare for that and prepare cross-examination of several witnesses, and therefore costs, of course, do mount. And in addition to that, and a point that I made before, and again, it's not insignificant, and that is one very troubling factor, is the factor that the other side seem to still be proceeding and putting forward in a very strong way the need to have video link evidence, or at least that possibility. And that was a major concern for us, because if someone doesn't want to come, who makes a claim doesn't want to come and be present within the jurisdiction on which they're relying to bring a claim, that raises all sorts of issues, particularly in circumstances where the claimant has put absolutely not a shred of evidence before the court as to its financial position, and we know absolutely nothing other than the fact that they've not paid checks have bounced, and that criminal proceedings were commenced. And for all those reasons, we say the security application should still be live, and some security should still be offered, and it does serve a purpose. It is not purely tactical. There is some real reason behind this.
Yeah.
Thank you, Your Honour.
Yes, Your Honor. The client this application is one of the
That's what I'm doing. That's what I'm doing.
Yes, in fact, thank you, Your Honor. This is one of the elements that has been considered in one of the cases cited by the claimant. In CFI Academy, which is in the authorities bundle, the Court of Appeal of England and Wales noted that the claimant can also rely on the fact that the application for security was not made at the outset. There may have been the reason for removing from earlier, but the fact is that the proceedings have been on foot for 9 months before the application was made. This is exactly the case here, Your Honor. The case started 10 months ago, and the defendant instructed the new counsel almost 2 months ago, and as Your Honor is well aware, the trial is going to start in 2 weeks now. The lateness of this application is also shown by the correspondence Mayor Brown sent to the claimant's representative. The letter on 19 April was sent at 2 p.m. and the defendant's counsel asked the claimant to provide, if the claimant was prepared to provide security for cost, and was waiting for an answer by the third thing tomorrow. On 20 April, the following day, the defendant sent another letter complaining that the claimant had not responded by first thing today. This again, Your Honor, the defendant doesn't take into account that the claimant's counsel has to take instructions from the claimant as to these very important points, and the claimant is out of the jurisdiction. And again, the claimant is not out of the jurisdiction because it has an aversion, as the defendant stated, but because first there was a criminal case pending, and now because it's trying to make arrangements actually to be in the jurisdiction.
Right. Let me put it before you this way, before I decide this application. Okay? I will adjourn this application until tomorrow, and I want to hear from the claimant whether they can put security of cost of only 300,000 dirham. Now 1 million. And then I will take decision accordingly. So your deadline is tomorrow 4 p.m. Is that right?
Yes.
Okay with me?
Yes.
Okay. Okay. That means we will deal with your security of cost application maximum by tomorrow. And I think you just heard my proposal to the claimant. Second application, which is the amendment of your defense, has been dealt with already, so on an agreement basis. And as regards to the first application, the appearing by video link, I would need a couple of minutes to think about and come back and then deal with the timetable of the trial. If you would give me 10 to 15 minutes and I will be back. Unless you want to tell me anything else.
Your Honor, it's fine from our side.
Yeah, that's fine.
May I ask a question?
Yes.
With respect to the security for cost, what would be the timeline to provide security? I understand it will be before the trial, but...
Yeah, I would say 5 working days maybe, maximum. Right?
Thank you.
Okay.
All rise.
Yes, we back, and we're dealing now with the first application. I'm granting the claimant their application for their witness to appear on video link for the reasons that the visa issuance is not in the witness' hand, but it is in the authorities, the immigration authorities' hand, so that when things, other things, if the application is not granted and the witness could not enter into the country, that would cause injustices to the claimant case. And there is a third factor, which that the knowledge of the criminal action discharge will come very late to the claimant. So for these three reasons, I'm granting the claimant their application for their witness to appear on video link. As regards to the second application, so it's by consent it's ordered that the amendment of the defense, of the statement of defense and counterclaim is allowed, except for the paragraph 67, where are the first and fourth sentences only allowed. The defendant therefore would submit clear and fresh statement of defense. Claimant with liberty to deal with these new changes in their skeleton argument or the closing submission. With regard to the third application, we will wait to hear from the claimant to reply to our proposal to submit 300,000 UAE dirhams deposit as security of course, or the court would deal with the application. Is that clear?
Your Honor, just on the video link, we've heard what the court says about that. I have taken some instructions, and what our clients are suggesting is that they are prepared to help assist Mr. Krayushkin with his visa application. We indicated before that we think it can be done quickly, and we are willing to help the claimant with that if they so wish. I'm also being asked to request, there was some mention before, I think, by my learned friend of a witness statement. If they could provide a short statement as to what steps they've done once they've undertaken those steps within a day or two, but we are willing to help them if they wish.
That's fine, and I really encourage, and not just encourage, I direct the claimant and the witnesses to take the reasonable steps and to apply and to get the visa and to appear in the court live instead of appearing in the video link. And I appreciate your offer to assist and your client's offer to assist in that. And I think both parties should collaborate and try to bring the witness into the courtroom instead of appearing by video link. Right, I think now, if you clear on the three applications, yes.
Before we move on, the time tomorrow, is it going to be, when you've asked for the defendant to come back and inform the court, will there be a further hearing, or should we just wait to hear from the court, or should we appear before Your Honour at a particular time?
There will be no further hearing. We've heard enough in regard to the application, so the court will decide the application.
I'm grateful.
We already heard.
Yes, thank you.
Yes, we'll move now to deal with the timetable of the trial. May I ask the claimant to take lead in this?
Yeah.
If you're ready.
It's in the file down.
Sorry, what is that?
Tab 5.
Tab 5. Yes.
Yes, I understand that this has been agreed.
Oh, is this agreed? Yes.
Yes. So this is what the parties propose. 1 hour each for opening submissions. First day. The first day it's going to be
Isn't 1 hour a lot?
Yes, Your Honor. We think it's probably a lot, but the defendants wish to have ample time.
Right, and okay, because that's what's taking you to go to the third day, isn't it? So can we cut 15 minutes from each the opening statement? So let's make them 45. Practice proved that 45 minutes is a
In that case, yes, Your Honor, we will do that.
Right. So then, yeah.
The claimant's witness, Mr. Krajewski, 15 minutes for his examination in chief, 2 hours and 30 minutes for the cross-examination, and 45 minutes for the re-examination. And the reason of this timings is due to the fact that Mr. would respectfully request an interpreter for Mr. Krajewski, so it could probably delay a little bit the examination.
Yeah, especially with the video link and interpretation, yes. So sometimes we expect technical problems with the video link. So I agree. So that's okay for the first day.
The second day is going to be claimant's further witness, Ms. Alina Bagata, and we propose 10 minutes for the examination in chief, 45 minutes for the cross-examination, and 15 minutes for the re-examination.
So that's 1 hour and 10 minutes. Then third witness.
And then third witness is Ms. Sahar Saleh, and we propose 10 minutes for the examination in chief, 30 minutes for the cross-examination, and 10 minutes for the re-examination.
So that's make it 50 minutes. So this is in total now 2 hours for the morning of the second day. Then
And then the defendant's witness, Mr. Louis Sabuni,
yes.
we propose the same timing that we propose for claimant's main witness, Mr. Krajewski, 15 minutes for the examination in chief, 2 hours and 30 minutes for the cross-examination, and 45 minutes for the re-examination. We understand that Mr. Sabuni also is going to have an interpreter.
Yeah, but why 45 minutes for re-examination? Why the re-examination would go more than the cross-examination itself? That's a lot of time, isn't it?
That was, I believe, the defendant's proposal. Mr. Graham? Sorry, Mr.
We're happy to knock that down. I mean, there is also a re-examination of Mr. Krajewski for 45 minutes, but we can knock both of those down to 30 minutes if Your Honor and the other side are agreeable to that.
Yeah, what I can see, the first 2 hours of the second day will be given to the AB and SS witnesses. That 2 hours, and then another 2 hours for the LS, which Du'ai Sabuni. That will make them 4 hours only. So then 2 hours for the closing submission. That's 6 hours. That will bring us to conclude within the 2 days.
Yes, Your Honor.
Yeah, and I think that's still reasonable.
Yes, Your Honor, we agree.
You okay with that?
Yes, Your Honor.
Yeah,
Thank you.
I'm okay with that too. Now we'll move to the trial vendor.
Yes, Your Honor. The index for the trial bundle has been agreed between the parties, and we're in the process of finalizing the bundles, and they will be ready and lodged with the court early next week, if that is agreeable, and a copy sent.
What's the date when you said early next week?
I don't have a copy of the case management order, I apologize, Your Honor, but I believe pursuant to the case management order was 1 week prior to the start of the trial. So that would be Monday of next week, if that is agreeable.
It's okay, man. Okay.
That's agreeable with us.
That would be, is that 2nd of May, isn't it?
Yes.
Yes. Skeleton argument? As usual, is that 2 days before the trial?
Yes, Your Honor.
2 days?
Yes.
So 3 days before trial for you, 2 days before the trial for the defendant. Is that right?
It's all right, Your Honor.
You're right.
We propose an exchange of skeleton argument.
Right.
Your Honor agrees as opposed to claimant submitting first and then the defendant.
Well, so the deadline, I want this. So Aisha, would you remind me, trial starting Sunday or Monday? Monday, isn't it? Tuesday.
It's a Monday.
It's a Monday, isn't it?
I believe it's Tuesday.
Yes.
Yeah, I guess it's Monday.
Oh, it's a Tuesday.
So,
The 10th of May is a Tuesday. 10th of May is a Tuesday.
my clerk says it's Tuesday. Tuesday and Wednesday.
May 10 is a Tuesday.
Yes, it's Tuesday. So the deadline for the last skeleton argument would be 4 p.m. Sunday, the 1st of May.
Yes.
So the week.
So it's consecutive exchange.
Yes.
So just to clarify, Your Honor, it's consecutive exchange.
I'm
So
talking about
the defendant will.
submission to court. You can exchange before.
Yes, but will the claimant put in their skeleton 3 days before the hearing, and we'll put in our skeleton 2 days before? Is that the order that's being made? Yes.
Right. Yes, Asha, have you took note of all of this? Well, okay. So we clear then in almost everything. The only pending matter is that application number 1 for the claimant witness to appear on video link. So we will hear from them by 4 p.m. tomorrow. And then maximum by the next working day you would have the decision on that application.
Thank you. Your Honor, there is one issue of costs, and can we ask for costs to be reserved on all these applications?
Cost will be in the case.
I'm grateful.
Thank you.
All rise.